Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be the new laws impacting residential landlords for the year 2025. Hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio. It is December 7th, 2024. And as we might remember, this day back in 1941 represented the worst attack on American soil. That was when the Japanese bombed Pearl Harbor. President Roosevelt at the time declared that this day would go down in infamy, and it certainly did. Our prayers go out to the service personnel that gave their lives that day. The song was, and the song I've always said is a theme song for my law practice, and that is Hit the Road Jack. That was performed by Ray Charles, and it was released in 1960. That was 64 years ago. And I bet you don't know that it was written by Paul Buckley and Jonathan Wolfe. So we know how this program works. I'm going to start with an opening topic, and then at the end, we'll open it up to questions and answers. If you're in the Zoom meeting room and you want to ask me a question, please electronically raise your hand. You can do that now so that you'll be first in line and be sure that I do get to talk to you. Okay. What's going on today? And my topic is the new laws impacting residential landlords in the year 2025. Did they make new laws for landlords starting 2025? And the answer is, oh, yes, they did. And would you guess that none of them are positive for landlords? They're all against us, ladies and gentlemen. It just does not go on in terms of anything in favor of landlords. They just keep chipping away our property rights, and it just really does not stop. So let's go over them. Let's move on to Civil Code Section 1950.6. I'm going to give you the abbreviated version of this because I went through all the criteria of this. You'd want to pull your hair out. But the abbreviated version of this is normally you're able to charge a tenant an application fee when you run a credit check after you've grabbed his application. Makes sense to me. Well, now there's severe limitations on charging him an application fee. So here's what the rules are. You can only charge an application fee if you have given the tenant in writing what your screening criteria is. For example, you have to tell them, look, I'm only going to take a tenant that makes 3 times more than what the rent is for that unit. I'm also only going to take a tenant unless his credit score is above 680. You have to have your screening criteria in writing to the tenant. Assuming you do, now you can charge him for that application screening process to run that credit check. However, it gets more insidious. They state that you have to take the first applicants whose credit met your criteria. So if you take 2 different applicants, and you run their credit checks on both, then as to the second applicant, even if you rejected him because he had terrible credit, you cannot charge him that application fee, and you're going to have to give it back to him. And if you don't give it back to him, you can be sued for that. So the way to handle this is, number one, make sure that you have your screening criteria in writing, hand it to your tenant, give that tenant that application to fill out. But you only want to run one credit check at a time. So as to that one, run it. If it fails, then you do not have to give it back to him. Then run the second applicant's credit. So you got to stagger these. If you run them both together, now you're going to have to refund to the second tenant that application, even if you rejected his tenancy on the basis of poor credit. Okay, let's move on. those balcony and stairway inspections that have to be done by a licensed contractor, that was due as of January 1st, 2025. They have extended that to 20 January 1st of 2026. So what is that? If you have a stairway or a balcony made out of wood, or partially made out of wood that extends from the walls of the building. So not that it's encumbered inside, but it extends past and it's over 6 feet off the ground. Then by January 1st, 2026, you're going to have it inspected by a licensed contractor. And then you're going to have to do it every 6 years, ladies and gentlemen. Another boondoggle. And God forbid somebody gets hurt on a balcony and you didn't have that inspection. You can just imagine how you're going to be hurt by not having complied with the law. So once again, it applies to where there's 3 or more units, where the balcony or staircase extends beyond the walls of the property. It's over 6 feet off the ground and is made out of wood or partially made out of wood. Then you're going to have that contractor's inspection report that has to be filed by January 1st, 2026, and you got to do it every 6 years. Okay, here's another one. Civil Code Section 1941.5. Your tenant is a single female, and she makes friends with some guy. You had nothing to do with this, ladies and gentlemen, nothing. But she happened to pick the wrong guy. And this wrong guy threatened her with abuse. And you're thinking to yourself, well, what does this have to do with me? I'm just the landlord. Well, if the tenant asks you to change the locks, you have to change the locks. And you have 24 hours to do it. And guess what? You have to pay for it, ladies and gentlemen. You have to pay because of her bad choice in boyfriend. So if she's any kind of a victim of abuse and she tells you to change the locks, you got 24 hours to do it at your expense. If you don't do it, then she can do it, charge you, and you have 21 days to reimburse her. Okay? So this is just absolutely insane that they're now putting the onerous on us. Now, there was another law similar to this where if you had, and this law has been on the books, but it's similar, and that is where you have a tenant who's asked you to make a lot of modifications to the premises prior to moving in, and you did that, and then you signed a 1-year lease with her. And then she claims that she's a victim of domestic violence. She has to have a police report or a restraining order. Then she can just walk on her lease after giving you 30 days notice. So the lease means nothing. Again, it's the landlord who's taking the abuse for possibly the poor choice by your tenant. But in any event, whether it's a poor choice or not, why is the landlord financially responsible for this situation? But that's what it is. Okay, let's move on. Civil Code Section 1954.07, tenant rent payment recording. This is a bizarre one, ladies and gentlemen. I'm going to really try to refine this to the best that I can, but it's just ridiculous. This is for leases that are entered into between January 1st, 2025 and March 31st, 2025. So for the next year, the first 3 months, you have to offer in writing to the tenant that you will report to credit institutions records of the tenant's proper and timely payments of their rent. And you have to offer that to the tenant by April 1st, 2025. So you have to do it in writing, where on April 1st, this is for any tenancy started between January and March of 2025. You have to do it in writing, say, hey, I'm going to report your positive rent payments to a credit institution, and you have to tell them which credit institution it is if you want me to, and you have to send that to them in writing, give them that offer, and there has to be a signature line and a date. If the tenant says he wants you to do that, then you have to do that every month. And the cost of reporting it is borne by the tenant up to $10. the tenant can opt out of this reporting. And if he does, then he can't opt back in for another 6 months. Now, if it costs you nothing to report, then the tenant doesn't have to pay anything. So it's what it actually cost you up to $10. Now, for those leases that started as of April 1st, 2025, that has to be offered right at the time of the initiation of the tenancy. And in addition, you have to, for both scenarios, those leases started between January and March of 2025, and those leases started as of April 1st, 2025 or thereafter, you have to offer that every year. You have to say to the tenant in writing, hey, if you want me to report your positive rent payments to this credit institution, please sign on the bottom and date it and send it back. You will be charged for that fee. By the way, you can't take that fee out of the security deposit if the tenant refuses to pay you. You can't use that as a ground for eviction if the tenant doesn't pay you the $10. All you can do is tell the tenant, I guess you could sue for it in small claims court, but all you can do is tell the tenant, okay, I'm not reporting anymore. But by the way, and I think the politicians are out of their minds with this law, uh, now that the landlords are going to know the easy criteria of how to report positive rent payments to these credit institutions, because you're going to have to do it, you're going to have to know the procedures. I recommend to landlords that you report negative payments. So when that tenant is 5 days late, report it. It might cost you up to $10, but please do it. So for the politicians that want to say, hey, I want to show how tenants all have great payments in terms of that they pay their rents timely, well, you know what? It might be a boomerang and come back to bite tenants in the south area of their body, because you should also report negative. Nothing prevents you from doing that. So that's the tenant rent payment credit reporting Civil Code section 1954.07, which you guys have to do. You have to offer that by April 1st to any tenants started prior to April 1st between January and March of 2025, or any tenancy that started after. You have to do this in writing. I'll probably have a form on my website that I'll create, but you're going to have to offer this. And then you got to offer it annually. Again, it doesn't apply to any tenancy that started prior to January 1st, 2025. Okay, let's move on. Code of Civil Procedure, section 1167 extends the time to respond to an unlawful detainer. So normally in the past, if you served an unlawful detainer an eviction lawsuit on your tenant, the tenant would have 5 days to respond to the court. That would be excluding Saturdays, Sundays, and judicial holidays. So if you had that as your time period, you would obviously want to file your default immediately, which is what our firm does. But now, of course, it's been extended. It's been extended now to 10 days, excluding Saturdays, Sundays, and judicial holidays. So right now, unlawful detainer cases are going to take at least another 8 days longer to complete because of this new law, which extends the time in which tenants can contest an unlawful detainer proceeding. Okay, let's move on. Civil Code section 1950.6. We know when you do a credit report, we've always said this in the past, that if the tenant wants the credit report, you say, I'm not giving you the credit report. I'm just going to tell you the credit institution and their address and their phone number that gave me the credit report, and which showed that it was negative, and you have to call them up. And it would have been a free service for the tenant to call that credit institution to get a copy of their credit report. But the landlord had no obligation to give the credit report to the tenant. Well, under that code section, you've got 7 days to give the report to the tenant, whether they ask for it or not. Anytime you run a credit report from now on, once you receive it, you have 7 days to supply that applicant with that credit report. 7 days, got to do it. We're going to come to the last one, and that's where they want you to deed your property to every tenant. No, I'm just kidding. Okay. This last one is 1950.5. 1950.5 of the Civil Code. And this is effective July 1st, 2025. Effective July 1st, 2025, the landlord, I don't make this stuff up, the landlord must take pictures of the unit when it is being leased. So go in there. I don't think that's a bad idea, by the way, because I recommend that. Take pictures of the unit when you're leasing it so you can show the condition of the premises afterwards. But it's now mandatory that you take photographs of the premises when you lease it out, effective July 1st, 2025. Now, effective April 1st, 2025, that's before that date, the landlord must take pictures of the unit after the tenant vacates, and also after the landlord has restored the unit to being re-rented again. So as of April 1st, when the tenant leaves, you got to walk in there and take pictures of the unit. When you have the unit prepped and ready to go, you have to take pictures again. This is going to, of course, save you with regard to when you're doing your security deposit itemization. You can prove what damage occurred. So I don't think that's too bad, but of course, it is onerous on the landlord that they're forced to take these pictures. And God forbid you don't, then I can see the tenant saying that he's entitled to all of his security deposit. Who knows what they'll say because you didn't supply the pictures, which you're supposed to do. So once again, effective 2025 in July, you have to take pictures of the vacant unit before it's leased. And then once the tenant vacates, as of April 1st, 2025, you take pictures of your unit once it is vacated. And then once it is, after it's prepped, you take pictures again of that. Of course, everybody has a smartphone, so it is easy to do so. That, ladies and gentlemen, constitutes what the hell is going to happen come after New Year's Eve, January 1st, 2025. I know I gave you a lot of information, but this is going to be, redistributed on YouTube, and I'll have some interesting pictures and text, so you'll be able to make it easier if you go back to the YouTube after I do the editing after this broadcast. We're now going to open it up to questions and answers. And we know the rules that this is for informational purposes only and does not constitute legal advice. If you do want to talk to me and you're in the Zoom meeting, please electronically raise your hand. If you have a case with me, we don't discuss specific cases. We only talk about general areas of law. And last but not least, if you have a camera, please turn it on when you're talking to me because it does make the podcast much more enjoyable if everybody can see who I'm talking to. And with that, we're going to open it up to our first participant, whose name is Rick R. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello, Rick.
Last year you helped me with a an eviction and got a stipulated judgment, and thank you so much for that. I have I want to go to the other side if I could, so to speak. I've got a tenant who's a friend, and he lives in Walnut, which is in LA County. There's two houses on one lot. It was built in 1944. He's 70 years old and he's lived there for 4.5 years with three family members. He pays 1,700 a month. He has a rental agreement with, let's call the landlord Mr. X. Um, Apparently Mr. X gave his son the permission to sell the unit, although my tenant never really got any, notice about this. But then the son gave the tenant a 60-day notice to vacate and then sold the property to a new owner. The tenant has never heard from the new owner. There's been no mention of relocation money. There's been no change of ownership. Um, which I think is supposed to be done in
Right, Rick,
50.
we're going a little far afield, so let's get to the chase with this. You said the property was in Walnut, correct?
Yes,
And there's two units on one lot.
yes,
And I presume this property was built more than 15 years ago.
1944.
So on that basis, you're subject to statewide rent control. The landlord just can't serve a 60-day notice on the tenant and ask him to move. So that notice means absolutely nothing. Uh, the fact that he's selling the property doesn't give him license to ask the tenant to move. So that's number one. A
Right.
landlord, an owner of property, has no obligation to tell his tenants that, hey, I'm selling the property. Once the property is sold, and we don't know if it is or isn't, but once the property is sold, the new owner has to inform the tenant that there's been a change of ownership and there's a bunch of criteria. That form, of course, is on my website in the free form section at evict123.com. So I would tell your friend that I don't think he has anything to worry about. He's a protected tenant. Now, if the new landlord wanted to have a close family member move in, then they would have to serve him with a proper notice indicating what family member is going to be moving in. In addition, he would be entitled to relocation. The relocation, unfortunately, would only be for him 1 month's rent.
Okay. Do you have any advice on who I know we talked last year a lot about, the state providing, or the county, whoever providing free advice for tenants. Is this still happening? I know he's talked to a couple people and they
Yeah.
want to charge
Uh,
him.
right. I wouldn't waste any time or effort right now because nothing's happened. He can ignore the 60-day notice. He should continue to pay his rent to the only landlord that he knows and sit there. If he gets something else, then you know what? It's real simple. He can find out himself without any problem by joining this telecast every Saturday at 3 p.m. and I'll be happy to talk to him.
Oh, okay.
All right, Rick, you
All right.
take care. We're going to move on to Jim Polina. Jim Polina, how are you?
I'm doing good, Dennis. Good to see you again.
Good to see you. I've been trying to call you. You haven't told me whether you approved that letter or not.
I'm going to modify it a bit and I'll send it back to you.
Okay, send it back to
Uh,
me modified. Jim is dealing with me on a letter that I wrote for him. So, yes, send it back to me and I'll take care of that. But right now, what's your question, young sir?
well, I have two questions. One is with pets. Is it still allowable to charge a pet rent and pet fee?
There is no such thing as a pet rent. There is no such thing as a fee. There is something called a security deposit. You're entitled to a security deposit, and that's it. And right now it's, as you know, it's 1 month's rent unless you have a total of 4 units in two properties. But there is no such thing as a pet fee. And the new code section, which says you have to accept a household pet does state that you can't charge anything extra for that. And by the way, someone asked me today when I told them about this law, they said, well, based on that, can I bring in 12 dogs? Based on the fact that if I start a tenancy after January of 2025, can I bring in 16 dogs? Well, my guess is no, because the way the statute is written, it says household pet. It doesn't say household pets. But again, this is something that the legislature should have tied down that you're allowed to bring in 1 dog, but not 15 dogs. Now, there are certain laws in jurisdictions. I believe in the city of Los Angeles, you're at the maximum of 4 dogs. Oh my God. That 4 dogs can be in an apartment unless there's some provision. But again, this law only applies to tenancies commenced as of January 1st, 2025.
Okay, got that. Second question. I have, in addition to my lease, I have a separate arbitration agreement. And I always present it first. And I have a policy, if the applicant does not sign the arbitration agreement, then I do not present the lease. Am I in violation of anything?
I don't think so, because that's just your screening criteria that if we're getting involved in any kind of a lawsuit, maybe you thought that I discriminate against you. I want to make sure that it's by arbitration. I don't see a problem with that.
Okay, great. Thanks, Dennis. I'll call you later.
Okay. Okay, moving along to Juan. Juan's iPhone. How are you, sir?
Hi, Dennis.
Hello, Juan.
Thank you for your services. I've used you a couple of times. I had a question. I have a gentleman that fixes and repairs my units, and the other day, one of the tenants, it was a lady, she asked him if he was afraid to get hurt by any of the tenants. So she said, because I instruct him to let me know when there's something wrong going on while he's repairing stuff, if he sees anything. And I guess she's been caught doing stuff she's not supposed to. And then, I give her like warning letters, so she's upset.
Well, I mean, listen, if you have a repairman going in to make a repair, that doesn't mean that his eyes just have to be in a tunnel vision with regard to the repair that he's making. So if he looks around and he sees that she has a small methamphetamine lab in the living room, he certainly can report that. If the tenant doesn't want to have anything else in view, then she should take it away so that he's only looking at what he's supposed to look at. But again, if he spots something, there's nothing preventing him from telling you the condition of the premises that he's viewing.
Yeah, but I took it more like a threat because she said, aren't you afraid that somebody's going to hurt you one of these days because you're telling on everybody?
Well, that's just casual, silly language by your tenant.
Okay. 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 Thank you, Dennis.
All right,
I,
Juan, nice talking with you. We're moving on to Anna. Anna, how are you today on a Saturday?
Hi, Dennis. I'm good. Thank you. How are you?
I'm good. It's Saturday. Going out to dinner.
Oh, that's nice. Um, Regarding that pet law, is that going to be for just like LARSO or is it like all of
This
California?
is everything I talked about was new state laws. So I don't care whether you're in Pismo Beach, like Jim is, or you're in San Diego. This is state law. Up and down, they are shredding our rights.
Wow, that was a shocker.
Yeah.
My question today though, is if I have a tenant that was on a lease and then they went month to month and they give me a 30-day notice that they're going to vacate and then they don't vacate, can I evict?
What city, please?
Los Angeles or Van Nuys.
And the
It's under
answer
RSO.
and the answer is no. That's not a ground to evict. There's 12 reasons to evict, and one reason is not. My tenant gave me a notice saying he was going to get out and didn't. That's not a reason to evict.
Wow. Okay. I didn't know that.
Remember, there's no laws in favor of landlords. So don't be surprised. It's just the way it is.
Okay, Dennis. Thank you.
All right, Anna, nice talking with you. Hey, Austin, how are you today? Mr. Austin.
Hey, good, Dennis. Can you hear me all right?
Now I can, young sir.
Oh, wonderful. A couple questions for you. So I bought this fourplex in the city of Long Beach, and I live in one of the units, two single family houses and a duplex on the same lot. When I first moved in, the tenant in one of my units was month to month. And he hadn't had a rent increase in a long time. So I raised it the maximum allowable by 8.9% at the time. However, 6 months later, I noticed the tenant's son, who appears to be over the age of 18, moved in with him. And I want to know, am I allowed to increase rent outside of the AB 1482 provision?
There's no provisions in the Tenant Protection Act that allows that. So you have the right to evict, but you don't have the right to increase the rent. Now, the next question I always get is, well, what if the tenant agrees and we enter into a new lease with this son's name on it and we ask for additional rent? Is that okay? And the answer is no, you can't do that either. So you're stuck with either evicting. Now, if you evict, of course, once the tenant's out, you're allowed to raise the rent to market value.
Okay, I'll consider that. The other thing I was asking is, Um, uh, the sheriff's lockouts, I received a quote for 4 months for sheriff's lockout, just very terrible in the city of Long Beach. So my question is, all the, a lot of these tenant rights organizations put props, on the ballot, Prop 33, for example. So is there anything to say that, all these apartment associations can't get together and put another prop on the ballot and just say, sheriff's offices are required to perform sheriff's lockout within so many days of receiving the writ of possession, giving landlords
I
some
mean,
relief?
you can legislate anything you want, but the reality is physically that the sheriff has to have the manpower to accomplish it, and if they don't, they're just not going to do it. For example, under the Code of Civil Procedure, landlords are entitled, believe it or not, to a trial date in 20 days. That's in the code. It's been there for a long time, but there's no chance you're going to get a trial date within 20 days. Plus, this delay is really only akin to the County Board of Supervisors for Los Angeles. Every other jurisdiction, for example, Ventura and San Bernardino or Riverside Orange, their lockouts with their sheriff's offices are going relatively quickly. LA is intentionally, and I think it's a plan by the County Board of Supervisors to slow walk evictions. So first they stopped us for 4 years from doing any eviction. And now that we finally have the right to prove our case, win a judgment, now we're being slow walked by the county supervisors. So, but I don't think an initiative is going to help Boston.
Okay. Thanks, Dennis.
All right. We are going to move on to Laura Corral. How are you?
I'm great. How are you?
I am fine, thank you.
Thank you for all you do and all the information you share with us. So next year, we're still able to go ahead and increase rent by 4% under LA's RSO. Is that correct?
Yes, as of February 1st of 2025, unless they change it. Currently, it's 4%.
Okay, so we could go ahead and start giving them the 30-day notice of that rent increase
And
sometime.
don't forget the mailing rule, young lady.
I won't forget that.
So we have to, and there's 31 days in January. So I would do this, I would do it probably between December 20th, and December 24th, right around there, to take effect February 1st for RSO properties for the city of Los Angeles. That's also true for unincorporated areas of LA County.
And my other question is regarding like cameras on the property. I have a tenant that has a camera inside his vehicle recording the premises 24 hours. I mean, we already have cameras on the property, but it seems like he's just doing it for surveillance. Is that allowable for
If
tenants?
he has the camera inside his car, I don't see a problem with that. If he tries to put a camera and attach it to the exterior of the building, that's something that you could deal with.
And I know there's like anti-landlord harassment laws, but there's no laws for tenants that are being harassed by tenants, right?
God bless you. That's correct. They need to make that landlords are the only ones who are getting harassed. It's insanity that they keep making these laws stronger for tenants. They had this anti-harassing law in the city of Los Angeles, and now they've strengthened it. But before they strengthened it, they received 14,000 tenant harassment complaints from tenants. 14,000. Only 6 were valid. So you can imagine all these landlords and what they had to go to prove that the tenant was whacked and that they didn't do anything wrong. And yet now, based on those criteria, they're now saying we need to strengthen this. Are you out of your mind? But that's where we deal with the City Council of Los Angeles.
Okay, thank you.
You're welcome. Jan, good afternoon. How are you? I think I lost Jan. You were right there. Let me,
hello?
I'm looking
Unmute. Unmute. There you go. Hi.
There you go.
Okay,
Sounds
great.
good.
Two of my questions were already answered, so great. I want to get straight to this one question, and it's about that rent control poster that's supposed to be in the common area.
Which city, please?
Los Angeles.
Is your property built before 1979?
After, before, way before.
Okay, so then there's two forms that need to be posted. One is that your property is subject to RSO, and then there's another form that's called the tenant protection notice. Those forms are on my website. You need to post both of them in a conspicuous spot, put them in some plastic, and post them there.
And is there any alternative to doing that? Like, could I attach it to the rent increase that's coming in February?
They're supposed
that
to
I'm
be
gonna.
posted in a conspicuous spot on your property.
Okay, that is it. Thank
Thank
you.
you. We're moving on to Fred Morris. How are you?
I'm good, Dennis. How are you?
I am fine, thank you.
Okay, so two questions here, Dennis. So I'm buying a property. It's a 4 units in Torrance, PO, which is part of LA. I want to move my mom in once I close escrow. I'll be calling your office because I'd rather you send the tenant because the tenant been there for over 10 years. I'm taking over the property, hopefully closed by the end of this month. I want to move in my mom into one of these units. It's either going to be, so it's basically 4 units. There's a single family on the same lot, and there's 3 units in a separate structure. For me to move my mom into one of those units, before I move her in, I do need to do a lot of remodeling because, again, they've been living there for a very long time. It's not in a great shape. What is the process? Basically, the 30 days notice, and then I can, it's going to take me 2, 3 months to remodel for mom to move in after. Can you kind of instruct me?
Okay, yes. First of all, is your mom moving into a 1 or a 2 bedroom?
It's actually going to be either the 2 bedroom or the 3 bedroom, one of those two.
Okay, well, let's pretend she's moving into the 2 bedroom.
Okay.
Okay, you have to take the last tenant that moved into a 2 bedroom. So if there's other 2 bedroom units on the property, then it's the last tenant is the one you have to select. If there's only one 3 bedroom unit on the property, which I presume that there is, then you
Yes.
can pick that one because that would be the last. Now, if a tenant's been there 10 years and is over the age of 62 for the city of Los Angeles, it is exempt from being evicted based on a family member. So you can't do that. So if the tenant's over 62 and been there 10 years, you're out of luck, my friend. Okay. But let's pretend you now have one that works within the criteria, and you also are picking the last tenant who moved into the unit. Then in that situation, we need to file an application process with the city. We have to get that approved. We have to pay relocation. Relocation can be anywhere from $9,900 up to $25,700, and anywhere in between, depending on how old the tenant is, how many years he's lived there, whether they have children or not. So I can go over the list with you once you become the owner of the property as to what the relocation is.
So give me a minute. So you're saying even though it's my mom, blood related, I have to pay those people for them to leave?
Unbelievable. Remember, we started off this broadcast talking about how our property rights are being eroded. Our property rights are being eroded. We can't control our own property. We have to allow dogs in. If we want our own mother to move into our property, what a laudable, nice son you are. You've got to pay this tenant who's on a month-to-month tenancy. He could leave whenever he wants. But if you want him to leave, you're stuck with paying relocation anywhere from $9,900 up to $25,600.
Oh my goodness. Okay. Is there any way around that, Dennis? If it's my own mother? I mean, if it's they're nice people, nice tenants. I mean, what is the best way to approach
All you
them?
can do is ask, you can try to do a voluntary vacate agreement with them. Say, hey, look, I'm thinking of remodeling or something. I'm willing to give you 10,000. You can try to see if you can save some money on that, depending on what the relocation is. But there's really no way around it.
So you would send them the letter, and I still have to pay them to leave, no matter
Yes.
what.
Yes.
That
And I
sucks.
would need to know the criteria of how long they've been there, whether they have children, how old they are. Then I could tell you exactly what the relocation is.
Got it. Second question, real quick. Okay, so another caller mentioned the 4%. I thought the new rule for the beautiful board of supervisors that I hate with passion, they lowered it to 3%, unless you have 10
Uh,
units or less.
you're talking about unincorporated areas of LA County, or are you talking about?
Correct. Correct.
I thought it was 4%. They could have lowered it. I don't know.
Because I think you spoke about that
I
about
know, I know
seminars.
that I know through the end of this month, December, I know it's 4%. I'm not exactly sure what the County Board of Supervisors have allowed after January 1st. I assumed it was still 4, but it wouldn't surprise me if it was down to 3.
Right, because you brought it up on the last 2 Saturdays ago, and I read it online too, but you did bring that up about unless you are a small owner, 10 units or less, you can only charge 3% with the new rules. So I thought you have an idea about that.
Yeah, I'd have to look it up, my friend.
Okay, appreciate it. Thank you.
All right, take care. All right, let's move on to, I know somebody who lives in New York. Hello, Janice.
How are you,
Janice,
Dennis?
I am fine, thank you.
What I wanted to ask is, I was thinking of setting up an LLC for my property, and then I read something in passing that there's something you have to file now if you set up an LLC, or you're going to be penalized, and then a judge stayed it. Do you know what I'm talking about?
Well, we do LLCs. In fact, the attorney in my office actually prepares those. And
Huh.
this attorney who's been in my office, I've been associated with this attorney for, believe it or not, 31 years. Can you believe that? 31 years. And you want to know something coincidental about this associate attorney? This associate attorney happens to have the same last name as mine.
Oh,
And she happens to be 31 years old. So it's my daughter. So she does them there. You do have to register, this is a state entity, so you do have to register your LLC with the state of California. You get a tax ID number. There are certain reporting requirements that you have to do periodically to the Secretary of State. It's just another boondoggle so they can grab a little bit more money from you. But those are the only requirements that I'm aware of. But Madison Block, if you call the office, she'll be happy to answer any of your questions.
okay. One other quick question. If I want to add addenda to a lease renewal, can I just add that as one page as an addenda, or do I?
Sure, as long as the tenant signs it, whatever you want to have as an addendum.
Okay, great. Thanks a lot.
Okay, Janice. Let's move on to Arlene. How are you?
You're amazing. Hi, Dennis.
Hello.
Thanks again. Sorry, trying to get the video going here. Sorry. Thanks
There
so
you
much
go.
for all you do. Just a couple of clarifications. I did the rent increase on my LARSO last March, so I can't do it in February. I need to wait till March to do the 4%,
That is
correct?
true. It's once per year.
One per 12 year. Okay. And then I have a single family in LA exempt from 1482. I can go up, is it 8.9%? Is that the max?
It's a single family house with only one
Single
house on the
family
lot?
house and one house on the lot, correct.
You can go up as much as you like, whenever you like. There is no limitations. You can go up as much
Okay.
as you like, whenever you like, if it's a single family home.
And just one last question. As far as reporting the rents, I haven't been able to locate, like for mom and pop, like just for a fourplex, any place to do that. Most of them you have to have like a big corporate type of account.
Trust
So
me,
have you
these credit institutions will starting this immediately. So I'm also sure that the Apartment Owners Association will have a system where you can just go through them and they'll do the reporting for you. So all the apartment associations, I would just check with them. And of course, the Apartment Owners Association, I'm sure will have something in place so that landlords can just contact them and report tenants that pay their rent on time if the tenant is requesting that you do that, or for you to report tenants who don't pay their rent on time.
Okay, and I'm looking forward to your webinar coming up too.
Thank you. Okay, moving along to, I think this says Fern Rice, I'm pretty sure.
Yes. Yes.
Did I pronounce that okay?
Well, Fern is my first name. I don't know.
Oh, I see.
They just
Fern Rice.
ran it
Got it.
together. Okay.
Okay.
Okay. So I have a question about the pets. What happens if the HOA doesn't allow pets?
Well, that might be a justifiable reason. But
Oh.
again, as I sit here and think this out, I don't think they have the right to do that anymore based on this new law. So I think the HOA is out of luck at that point, because just like landlords are out of luck, the HOA is out of luck. So if the HOA says no pets, that's nice. Go check the law.
What about the number of pets?
Well, again, the statute says household pet.
Pet.
So I'm gonna mean that they can bring in one, but they can't bring in more than one if your rental agreement prohibits that.
And is there a like in the law, does it say up to a certain maximum amount, weight?
No, there's
Or-
no criteria. In fact, it specifically says you can't limit it based on weight or the breed of the dog, etc. So you have to
What
take that
happens if it's not a
Rottweiler.
dog?
Well, it's a household pet, so that could be a cat. I don't think it's an orangutan because I don't think that's a household pet.
Okay. All right. Okay. Thank you for your help.
Thank you. Kelly, how are you?
Dennis, what's happening? Hi, everyone.
Hey, another day.
Thanks so much for doing this. This is very informative. What's the rule about the mailing the info when you do the rent increase? I'm not sure with that one.
If you're doing a rent increase, you have to do, if you're doing it 10% or less, it's a 30-day notice. If it's more
Right.
than 10%, then it's a 90-day notice. However, if you're mailing it, you got to give an additional 5 days for mailing. So, for example, you could mail it on Christmas Day,
Got it.
and then that would be 5 to take effect as of February 1st.
Okay. But if you're posting it to their door, you don't have to mail it.
Well, I don't know. You have to, there's the criteria is you either hand it to the tenant or you mail it. That's the criteria.
Okay.
So if
Perfect.
you mail it, give an extra 5 days.
Okay, perfect. Balcony stairway. We've already done the balcony stairway for our buildings. We have buildings in Santa Monica and City of LA.
Yes.
The company I went with, they said that they didn't have to file. We have to hold it. If they were asked for it, then you show it. And
I
you're
thought
saying
you did have to file that. I could be wrong on that issue, but
Okay.
I know you at least have to have it.
Okay,
I
yeah, we
thought you
have
had to
it.
file it with the state and there was a place to file it, but I'll tell you what, I'll check that out for the next telecast.
Cool. And then does it have to be with the camera or the scope? Because I've had several different people. One was like, oh, you have to do the camera, the scope, but you have to get the asbestos test. So then it makes it more expensive for that company. Then the other companies are like, no, you don't have to, cut a
I
whole
don't
scope.
I don't think so, but I'm not sure of the criteria. I know you have to use this licensed contractor who does balconies. I don't think it has anything to do with asbestos. I think all it has to do is that they're checking for the how
rot.
sturdy it is.
Yeah.
That's
No, it was the one specific company was like, oh, if we're using a scope and a camera, you're opening up the stucco, so you have to do the
and
asbestos.
that might be true. If you're
Right.
disturbing that, then that might be true. But get yourself a different contractor.
Yeah, no, I didn't go with them because they were very expensive. And then last question would be, I have a tenant who wants to rent a new apartment starting January 1st. So basically, it sounds like I should make it start December 31st, correct?
Absolutely. Yeah.
Okay. Awesome.
Smart.
Thank you so much.
All right, bye-bye. That's a good point. Marco, how are you? Marco, if you'd unmute yourself. Okay, Marco, we're going
Did
to.
it work?
Oh,
Did it
now I
work?
can hear you. Go ahead.
Okay. Yeah, I talked to you before. I want to take a paralegal course, and I've been, watching your webcasts and on your site, and I have questions about the 3-day pay or quit. You mentioned in one of the webcasts something about sending a renewal notice, that every year you get a renewal notice for your apartment building, and you have to send it every year to your things, but also before you send
Okay,
a
yeah,
3-day
what
pay
you're
or quit.
referring to is the city of Los Angeles requires that you register your unit. You get a registration certificate each year. That's for our SO properties only. And technically, before you serve a 3-day notice, you're supposed to mail a copy of your rent registration certificate with the current year on it to each of your tenants.
Okay, so that's Los Angeles. And then you also, like the woman brought up, or someone brought up those tenant protection things that need to be posted. I know that was in your 3-day pay or quit thing, but why? Why is that
No, it's the
relevant?
city of Los Angeles and other municipalities, such as unincorporated areas of LA County, require that you post these notices in the common areas of the property. So if your property is under RSO, there's actually two notices to post. If it's not under RSO, and maybe it's just a single family residence, you still have to post that tenant protection notice.
But what does it have to do with the 3-day pay or quit?
Well, I'll tell you, if you're not in compliance with the rent stabilization ordinance, then that would be a defense to any unlawful detainer action. So if you don't have it posted, the tenant can come into court who hasn't paid rent in a month of Sundays. You did everything correctly, but he says, hey, there's no signs posted on the property. Therefore, he's not in compliance with the rent stabilization ordinance. That's a defense to my case.
Okay, and then speaking of the rent, why can't you charge rent during an eviction process? Like if they owe money from like 2 months ago, why can't you just keep getting the rent and try to get the back rent?
Okay, because it'd be really inconsistent. On one hand, you're saying, I'm evicting you because you didn't pay me the rent for the month of, let's say, September, October, November, but I'm going to take December and January and February. It would make no sense. When you take that rent, you're considered waiving the previous rent. So that would ruin your lawsuit. So you cannot take, once you start these evictions, you can't take any rent whatsoever. Even if you're evicting, for example, on an unauthorized occupant, which has nothing to do with rent. So I start the case in November, and then the tenant gives you the rent in December, and you cash that check. You've just ruined your case. We'd have to start it all over again.
Okay, is there any way I can find like the information about all this stuff?
I mean, everything's online, but the
Yeah.
the issues dealing with landlord-tenant law, as with any area of law, it's vast. And people think, oh, this is an easy area of law. The regulations and the requirements are insane, and most attorneys fall on their face unless they do this on a regular basis. And I'd say the same thing for myself in terms of, doing a dissolution for somebody. I wouldn't know the ins and outs to that because I don't deal in that area of law. So,
So,
but the,
yeah, I'm sorry. On Avo, they said it's something about a forfeiture that the landlord forfeits. It's a forfeiture. What does that
well,
mean?
anytime you serve a 3-day notice to pay rent or quit, you're declaring a forfeiture of the lease, which means that at the end, you're getting kicked out. This lease is over. So in every notice, it has that language that you're declaring a forfeiture of the lease. Anyway, Marco,
Okay.
thank you very much. We are going to move on to Alex. I'm going to ask you to unmute yourself.
Dennis, can you hear me?
I can. Hi, Alex.
Awesome. Thank you so much. So I'm buying a duplex property. The tenant on one side hasn't been paying rent. The listing agent made an agreement with her or gave her a 3-day pay or quit and made an agreement after the fact saying, hey, we're going to do cash for keys. Apparently, the tenant has agreed that I am going to close escrow before supposedly she moves out, though. Let's just hypothetically say I close and she hasn't moved out and the agreement of the cash for keys is still in place. What recourse was there? I'm just trying to cover my bases just in case. Do I have to issue her a notice or, I mean, what are your thoughts?
What city is your property?
Sacramento.
Okay, I don't believe Sacramento has their own rent control statute, but I'm not sure. But if they don't, then you're under statewide rent control. If the tenant signs an agreement to move by a certain date under statewide rent control, you can't bring forth an eviction based on failure to move. So even though you're the new owner of the property, as long as you've complied with what the terms of that cash for keys agreement is, then if the tenant doesn't move on that date, you as the new owner you can start the eviction process and make sure that when you become the new owner that you do that change of ownership notice, which is on my website.
Fantastic. Thank you so much, Dennis.
No problem. Good luck. Okay, let's do Belinda. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
How are you?
I'm good. Saturday.
Awesome. Thank you so much for this. So my question is, I have a fourplex in Valley Village, and we're remodeling the garage into an ADU. And we gave a 30-day notice for the one car that's affected, really. And the first date of construction would then be December 26th, but now they say they want to start demolishing on Tuesday. And so I'm wondering, can I talk to that tenant, and if she's okay with it, we could start, or can I
Yeah,
get
I
in
mean,
trouble?
of course, you can always talk to a tenant and augment the terms and say,
Yeah.
hey, I need you to get out. Maybe you want to give her a little cash extra for that inconvenience, but
Yeah, that's what I was thinking.
that certainly is permissible.
Okay, so we're not gonna get an issue.
No, not at all.
Okay, perfect. And then the second question is, if someone moved in, say, July of last year, do I have to wait until July to up the rent the 4%, like once a year?
Absolutely, it has to be each year, correct?
Okay, so I can't do it like January 1st. I
No,
would have
not
to
at
wait
all.
1 year. Okay, perfect. Thank you so much.
All right, thank you. We are moving on, and our last caller will be Mark Smiddle. I'm going to ask you to unmute yourself.
Well, hello, Dennis.
Hello, Mark.
So 1 year ago, I took your advice and I got out of California. I'm in the great state of Texas now.
Oh my God, God bless you, because you have something called property rights there.
Well, I do, but unfortunately, I still have some property in California. And currently, everything is vacant. And I have considered moving to this midterm rental model. And my question for you is, do we still have some protection with the, as long as we keep our rental agreements less than 12 months?
First of all, what city is this property located in?
So I have one in Signal Hill and I have one in the city of Long Beach.
City of what, please?
Long Beach.
Long Beach. Okay, as long as the tenants have been there less than 1 year, then you don't need cause to evict because you're basically under the auspices of the Tenant Protection Act, statewide rent control. So I would just do like a 6-month lease or maybe even an 8-month lease and then tell them that, hey, the lease is over, I'm not renewing.
Oh, I see. So do you see anything in the foreseeable future that would change, that our wonderful governor?
I don't think so because, Proposition 33 tried to destroy landlords and that was soundly defeated, thank God.
Yeah.
But I don't think there's anything on the horizon. So I think you're okay as long as you don't rent it out for a year. I mean, just do it less than 1 year.
Yeah, absolutely. All right. Well, thank you so much.
All right. Thank you. And I want to thank everybody for joining this Zoom Landlord Tenant Talk Radio. You know, we do this every Saturday at 3 p.m. If you're in the YouTube meeting, I would ask that if you could like my YouTubes and also subscribe to the channel because it really does help me. And with that, ladies and gentlemen, have a great Saturday, Sunday, and we'll see you next week.